we're staying on this breaking news coming into the studio. Let's bring in America First Legal Vice President Gene Hamilton. Gene, this story coming in, Special Counsel Jack Smith is asking the court to do a narrowly tailored gag order to restrict former President Trump's speech because he's claiming that it would be prejudicial materially in the 2020 federal election case. What do you make of this?
Liz, every American at home should be shocked and appalled by this filing by Jack Smith. It goes to the heart of what Donald Trump represents and what he has represented to so many people across the country, which is fighting for the average American, fighting for the common person against this behemoth, this government, this deep state. And what we see here is not only an unprecedented attack on somebody who's the major party nominee, or who hopes to be the major party nominee for president of the United States, trying to be silenced. So you have the federal government, the Department of Justice, the deep state that is bringing unprecedented charges against Donald Trump, against a candidate for president. And not only are they doing that, but they're saying, you can't even defend yourself in the court of public opinion. You can't even say a thing about this. Otherwise, we want the judge to throw you in jail. It's outrageous. This is unprecedented. This is an attack. It's an assault on the First Amendment. And every American at home should be shocked and outraged. Yeah,
it's really quite a thing about free speech here. I know, Gene, let's move on to this. The New Hampshire Secretary of State, David Scanlon, said that there is no legal basis for keeping former President Trump off the ballot in the First in the Nation primary. You know, we've got officials in a growing number of states. Last we checked, there were something like 13 states were debating whether to keep Trump off of their state ballots. What do you think of New Hampshire here?
Look, Liz, I am just continually dumbfounded at the spaghetti against the wall legal approach by the opponents of Donald Trump. We have, again, rightfully so, the New Hampshire Secretary of State acknowledging that there's nothing in state law and there's nothing in the 14th Amendment of the United States Constitution that precludes Donald Trump from becoming president. And yet you have all of these legal talking heads on major networks all across the country and folks, liberal hacks basically, saying, well, the 14th Amendment says something about insurrection, and we think that maybe Donald Trump was insurrectionist, so it has to work. It has to prevent him. But again, this is exactly what has been consistent. This has been how Donald Trump has been treated since day one, since 2016, since 2015. This is exactly what the deep state does to people, and it is infectious. It's everywhere. It's not only at the federal government, but it's at the state government. They are scared, they are afraid of him, and they are afraid of what he represents.
And, Gene, we've got this action in Georgia. The judge on the Georgia 2020 case says Trump will not face a speedy trial next month in October. You know, that's a setback to Fulton County DA Fani Willis. Willis had insisted that Trump and all of his co-defendants in the Georgia 2020 election case be tried together in October. We've got lawyers Sidney Powell and Kenneth Chesebro. They won their demands for a speedy trial. Now it looks like Judge Scott McAfee is basically saying, you know, Trump, you're not going to be tried in October. There could be a delay in his trial. But let's stay on this, Gene. I want to point this out. DA Willis suggested making defendants who don't want to go to trial next month waive their speedy trial right under the Constitution, saying, you know, this is going to be a logistical quagmire if you don't do it my way.
Liz, this is, again, just something where the entire paradigm that we're operating under, if Fani Willis had her way, is completely incorrect. Why do we have speedy trial protections? We have speedy trial protections for the protection of the defendant, to ensure that someone doesn't languish in jail and doesn't hang over with charges hanging over them from the government, threatening them with the potential of being thrown in jail for a long period of time. But if you have a very complicated case, if you have a very complicated matter, like what you have with this case, with this, again, unprecedented use of the RICO statute for political purposes by Fani Willis, you might think you actually might, as a defendant, you might want a little bit more time. And in fact, that is the defendant's right to invoke a speedy trial. And it is the defendant's right to say, no, I need more time. My counsel needs more time to review the evidence that's before us. And so, yes, this is actually, it's a good development that the case is being severed and the cases are being split up, because you can't rush something like that.
Got it. Gene Hamilton, thank you so much for joining us tonight.